My name is Jack Nyman. I'm the Executive Director of the Stephen L. Newman Real Estate Institute at the Zicklin School of Business, BARU College, City University of New York. I want to say thank you to our host, Zetlin & DiChiara, one of the city's leading construction law firms. We're proud to be sponsoring today's event, along with our media partner, Real Estate Weekly, and our association partner, the New York Building Congress. Today's event is about planning and understanding the impact of construction on adjacent properties. It's about averting serious project and economic consequences as a result of that construction. You'll hear from our important industry leaders and top professionals about what can go wrong and how to avoid unexpected problems from occurring through forward-thinking solutions. You'll learn about groundbreaking information that will help you break ground more successfully when you're building your next project. Now let's get started with today's event. There are very few attorneys in the construction industry who have the depth of knowledge and experience that our program's moderator has, Michael DiChiara. Michael is the co-founding partner of Zetlin & DiChiara, an experienced and recognized attorney in construction who has successfully handled some of the largest design and construction cases in recent times. In addition to litigation and contractual matters, he often advises clients on financial affairs and general business matters covering partnership law, corporate law, employment law, and professional practice matters, including ownership, transition, and licensing issues. Michael serves as general counsel to many of the country's larger engineering and architectural firms and represents owners, developers, engineers, architects, construction managers, contractors, and other parties in the construction industry.
As we all know, New York is essentially a forest of buildings. Small, big, old, middle-aged. When you build in New York City, it's rare that you don't have to worry about the building next to you. Today's program is going to focus on how do you approach that and how do you deal with that so that you can avoid seeing people like me, because if you see me, it ain't good news. If you see my partner, it's very good news because he's going to help you avoid seeing me, which means you want to avoid litigation. So from a legal perspective, avoiding the pitfalls and properly addressing the legal issues related to building next door and taking us through a rather straightforward and simplistic analysis, given the time constraints we have today, will be my partner, Ray Mellon. Next, we're going to hear how a major developer dealt with a problematic neighbor when he was building a wonderful new office building, 250 West 55th Street. And that story is going to be told by our good friend, Rob Schubert. And as you all know, Rob is one of the preeminent people who actually get buildings built in this town. Following Robert, we're going to hear from two of the top engineers around. And these are the fellows who actually have to figure out how these massive buildings get built next to existing buildings, whether they be small and somewhat fragile, or, you know, new condominiums. Heaven forbid if you damage a new condominium. You can imagine what the damages would be. But these are the guys who actually figure it out and make it happen. And without them, you don't have building in a city like New York. And finally, when he appears, we're going to hear from Tim Lynch, who's actually had to deal with these issues from the building department perspective. And you'll hear what Mr. Lynch has to say, because that's, I think, particularly insightful in terms of how do you deal with a local government, how do you get the approvals that you need, how do you stay on the right side of that foul line. Right, without further ado, because we have a lot to get through this morning, let me introduce my partner, Ray Mellon.
When you're building in the city of New York, in this congested area, you want to maximize your floor space. That means you're going to butt up against another property. And when you do that, you're going to impact that property. So you have two parties here. You have the adjoining property owner whose building is existing and they're happily utilizing it, and you have the developer. And they have conflicting goals in this situation. The developer's goal is, one, to get their project online as quickly as possible and as economically as possible. And at the same time, with the adjoining property owner, they have a different goal. They don't want you to go so quickly. They don't want you to disrupt their lives. They want the interference with their building to be as minimal as possible. And of course, paramount to everything is they don't want any damage to their property and or the occupants in the building. So you have this conflicting parties and positions. So what do you do? Well, let me first say that one thing that both parties have in common, or should have in common, is the fact that, above all, safety has to be paramount. In order to resolve these conflicting issues, one of the things that I always advise people is most important is, whether I'm representing a developer or adjoining property owner, and I've done a lot on both sides, is to communicate, and communicate early. That's when most of the issues are resolved, when it's done early. Most of the problems that I've come into on jobs is where the parties have not communicated early and just went forward with things. Now, in the communication, you can resolve these problems in two ways. One, ideally by entering into a license agreement. License agreement is a document that allows one party, here the developer, to go on to someone else's property to do certain work. And it can be work to protect that property or work to fulfill your construction of your own property. Now, that's the ideal situation. If the ideal situation can't occur, there is an option, and the option is going to court. And I'm a trial attorney, and I'll tell you the first thing I tell everybody is try to avoid going to court. It's time-consuming and expensive. But there is a procedure out there. It's a summary proceeding under the Real Properties Actions and Proceedings Law, Section 881, which allows you a temporary license to go on to someone else's property to effect your construction. But let me say this, and I'm going to repeat it ad nauseum through this little presentation because I want you to, if nothing else, to take this away. It doesn't apply to underpinning. And I'm emphasizing that because I've recently read some articles by some attorneys who are saying RPAPL 881 can be used for underpinning. Wrong. It can't. I'll go into it later. There's a case right on point. Now, experienced developers know that they have to communicate, know that they have to engage the property owner next door and enter into a license agreement. I have found in the past that it's the inexperienced developers that don't know this. You know, remember in the, before the crash, everybody was a developer. You know, they were accountants one day, and the next day they were developers. And at that time, the labor pool was also getting very thin. So you had just the makings for disasters, and there were a lot of disasters in terms of issues with adjoining property owners. That's where it happens. And frankly, I'm getting a little fearful now, given the state of construction, that we're starting to get to that stage. Right now, the money is in, the smart money is still building. You still have a lot of competent people working, but that pool is going to be drained, and that's when the problems are going to occur. Well, when you have this problem, this conflict, what do you do? Well, the developer knows that the building code requires that they protect the adjoining property. Chapter 33 of the code is the one that is here for this position. Starts out by saying you have to protect, if you're doing construction and demolition, you have to protect the next door property. Number two, the code says get a license to go on to the property next door, because that's how you'll be able to effectuate things. It doesn't mandate that a license be given to you, but you should get a license to go on there. And interestingly, it gives an adjoining property owner a real hammer if it's a multiple dwelling. The landlord in the adjoining property could say, okay, I'm going to give you access, but you could have rent stabilized or rent controlled apartments, and they may not give you access. The code says if they don't give you access, that is a basis for terminating the lease. That's a powerful tool in this city with regulated apartments. Now, three, physical examination. This is something that's in the code that even if you don't have a license agreement, I very strongly urge that you do this. And the idea is you go into the property next door and you take a pre-construction survey. And it's very important because you take the building next door as you get it. It can be a very old building, and it's going to have flaws. And you want to document every single crack, every single problem. Because if you don't, believe me, they're going to claim that none of that was pre-existing. It all happened because of your construction. And I urge clients also to give that material to the other side so they know exactly what you know. If you do an excavation, you have to protect the property next door. Now, this is from the 2008 code. The 1968 code had a feet, I think it was 10 feet. If you go down more than 10 feet, you have to protect the property next door. That's been changed now. But one thing I do want to mention is that under the 68 code, there's a recent case by the Court of Appeals, the highest court in the state, which said that if you do excavation and you damage the next door property, you are strictly liable for damages. Now, that didn't apply yet to the new code, but I'm sure it's going to because it hasn't changed in any material way. But what I want to point out here, if you look at the last part here, it says you should get a license to go onto the other property, and you should get the license from the adjoining property owner. And if you don't get it, the code says that responsibility to protect the adjoining property devolves onto the adjoining property owner. Now, that's in black and white. Do not believe it. And that's the important thing you have to realize about this. It's not simply that you understand real estate when you're doing these things. You have to understand construction, and you have to understand how the building department works. Building department doesn't care about that. It's your responsibility. It never devolves onto anybody else. And I'll give you a great example about that shortly. Next one, underpinning, the big one. Because underpinning is so important to developers because it maximizes your space and what you want to develop. And in this situation, I'm not going to go into this in depth right now, but look at the first couple of words. Whenever underpinning is required, that's the operative word. That's very important, and I'll tell you why later. But again, if you look down here, the same language about the responsibility, if you're not allowed to do it, you can't go onto the property, it devolves to the other property owner. Do not believe it. It doesn't devolve to anybody. Now, 33099 talks about weatherproofing, the integrity of the adjoining property. And this is something that a lot of developers forget about. You could be building, and Rob Schubert will give you a great example. He didn't forget about it, by the way. But they demolished the buildings, numerous buildings, and you have buildings next door that their exterior wall hasn't seen the light of day in 50, 70, 100 years, and they are not in the condition they were then. They're very porous, very fragile walls. They have to be protected, right away. So you have to do certain things. You have to certainly protect it for waterproofing so there's no water infiltration, because then you're just going to have more damages. But you also have to do things like if you have a masonry building with wood joists standing for 100 years, those joists are probably not in the pocket anymore. So you have to brace them back, open up the walls, pin them, pull them back, and brace them. You have to stabilize that building before you do anything really on your property, and that's very important. Now, the last one I'm going to speak about is the basic one, the protection of roofs, skylights, chimneys, etc. If you're demolishing a building that's above the building next door, you have to protect it. If you're building above the building next door, your property is going higher, your building, you have to protect it. And again, you'll notice here, if they don't allow you to do it, it's their responsibility. Doesn't happen. But let's talk about license agreement. What are the typical things in a license agreement? First and foremost, you have an express license, whereby the adjoining property owner is saying, you can come onto my property and you can do certain things. Now, the certain things, that goes to the second item, the scope of work. Now, the scope of work about what you're going to do on that property should be very defined. You want to know exactly what they can do and what they can't do, because problems occur when you don't specify that. Now, certainly a developer will want to really focus just on the protective work. What I often do is have in a license agreement a set of plans, the site safety plan, of course, and the plans themselves of the building. and with emphasis on what it is that the developer is going to do for the adjoining property owner. But one thing I do when I'm representing adjoining property owners, I insist that we be able to review the entire plans. And you get pushback from developers on that. And it's not, in essence, that we want to say we want to have a veto power of your height of the building, the aesthetics of the building, the placement of windows. It's none of that. What it really is that we want to evaluate totally the construction's impact upon next door. And you really need to see the plans to do that. I find that we have tough negotiations to come into a license agreement. But once you get into a good, comprehensive license agreement with provisions for what to do in the future, you don't have a problem. You have problems when you don't have a tough license agreement that covers everything. Paramount upon everything is safety in the city of New York. And the courts want you to be able to construct things in safety and protect the public. So, but let me tell you why underpinning doesn't apply. And it's because of a Second Department Appellate Division case. And just so you know, we're in the First Department here, which happens to be Manhattan and Bronx. The Second Department is all of Long Island, all the other boroughs, and whatever upstate that counts. But it's the only decision on point. So it applies in the First Department. And it's a case called Broadway Enterprises versus Lum. It comes out of Queens. There's two adjoining property owners. And it's a compelling case, actually, for the developing property owner, because he had a verbal consent from the neighbor that he could underpin. And he goes through about 85% of the underpinning. And then the adjoining property owner had some sort of epiphany and realized, I've got leverage here, and withdrew this quote-unquote consent. DOB came in, issued a stop work order. They couldn't agree to anything because now the adjoining property owner wanted a large license fee, wanted a brand new kitchen, wanted all new windows. So the developing property owner went to court, sought a license to go in and underpin the property. Now, the trial court in Queens and the appellate division said, no, you can't do it. And they did it on two bases. One was that it's a permanent encroachment. You putting underpinning on someone else's property is permanent. It's a trespass. A license under 881 says you can temporarily go in there and do what you're doing, because otherwise you can't go onto someone else's property. That's trespassing. The license says you're not trespassing, but it's temporary. When you underpin someone's property, it's not temporary, it's permanent. Even though you're improving the property and making it more stable. The court said that's a permanent encroachment, a permanent trespass. You can't do it. And the court said, which is equally important here, and harkens back to the point they told you about underpinning, where it said when underpinning is required. It said you can't do it because you have alternatives to underpinning. Now, what alternatives do you have? Well, first of all, you don't have to go so far down with your foundation. You can go at the same level. Then you don't have to underpin. You could use secant piles. Expensive, but you can use it. Or you can set back your foundation. You're going to lose square footage, and that's going to be expensive to you, but that's an alternative. So when you look at 33095, the underpinning provision, when it says when underpinning is required, it's never required. You're never going to get a court to say it's required here, it has to be done. Maybe Tim may say in an emergency situation, but that's different. That's later on after the proverbial already hit the fan. But in terms of starting out, you're not going to get a court to say that it's required. You always can do something different. Now, going to court, think of 881 as a single-purpose lawsuit. It allows you to go into court for just one purpose. You start with a notice of petition and a petition. You say to the court, I need access to go onto this other property to do this work. You can get into court quickly. You serve it on 20 days' notice. You can get in within a month, 6 weeks. However, if there's an emergent situation, you can go in right away. And I have an example which Steve's company was involved in, on the good side. I emphasize. A friend of mine was developing a property up on 3rd Avenue, and it cantilevered over another 6-story property which they owned. But by cantilevering over it, the zone of protection was extended. And it extended onto another property where they'd have to protect the roof once they get higher. Well, they were all set up to bring in the steel for the cantilever, and they went up 6 stories. And on a Wednesday afternoon, the best squad comes out and looks at everything beforehand because they got a permit to close down 3 lanes of 3rd Avenue for a Saturday to bring in the steel, which is already on its way. It was a massive undertaking. The best squad comes out and says, hey, what's the story with that building next door? It's no protection. And my client, naively believing this devolving language in the code, says, we tried to get in touch with them. We did get in touch with them, sent all the appropriate notices, and they said no. And they showed the notices to the best squad. They showed the responses, said, no, we're not going to allow you. And the best squad said, we don't care what it says. You got to protect it. And which, by the way, is exactly the right thing to do, because the best squad is only saying one thing. We want the public to be protected. So I got a call on a Wednesday night about 8 o'clock from my client telling me this. And so I obviously had a late night. Next day, Thursday afternoon, went into court, got a TRO signed, bringing in the adjoining property owner on Friday. And everything's going on Saturday, and we're talking about hundreds of thousands of dollars worth of work. We spent all day in front of Judge Sherry Heitler, and she tried to resolve it. And by the way, in an 881 situation, the judges always try to resolve it, try to bring people together. She couldn't do it. Ultimately, she sided with me, issued an order, and the work, Steve's company did the engineering miracle of the cantilever in this major building. But you can get in with 881 immediately if you need it. Now, let me quickly say, in terms of an 881, what can you expect? Well, it says here, as justice, as such justice requires, upon such terms, in terms of how the judge will fashion it. It's equitable relief. The court is very concerned about the impact upon the adjoining property. So you can expect, even though you're starting the 881 proceeding, that you're going to end up paying the architects and engineering fees and probably the attorney's fees, although there's some cases going back and forth on that. But additionally, the court, while they won't order a quote-unquote license fee per se, they will order payments if you are inconveniencing the other side. And that's important because there's one case that sort of illustrates it. A person didn't have a backyard, had a deck on top of an extension, and that's his only backyard. The next door neighbor, building was going up, was going to cantilever 6 feet over onto the deck and just totally take it out of play for 2 years. In that situation, the court said, you know, you're going to pay for that. And they made them pay $3,000 a month during the time period. And the court will also oftentimes put a duration, because they don't want to give open-ended time for the developer to do this. You want an incentive for the developer to finish the work quickly. Attorneys love war stories. This is one that Tim's aware of. An inexperienced foreign developer came to New York last year, developing a property, small pocket property in Midtown, where the bedrock's very high. My client's a pre-existing, pre-war condo, and they didn't do anything in terms of communication like I spoke before. They damaged my client's property. My client retained me. I came in, clearly saw the damage, spoke to the attorney for the other side, and I don't want to characterize things, but there was a level of arrogance and ignorance, if you will. By the way, a very good real estate firm, but they're not a construction firm. And they just poo-hooed everything. And it was clear there was damage, and as a result of that, I contacted the DOB, and the DOB came down and shut down the job for quite a long time because there were serious damages. In fact, part of my client's property was vacated. They had to do a remedial shoring, emergency shoring. And the upshot of this is now, as a result of DOB and the Tim Lynch's intervention, this is a very experienced developer. They're doing the work now perfectly. But they learned the hard way because they didn't communicate. And if they do future projects, they're going to be ideal. They have 18 people now. They know what they're doing. But they did learn the hard way, and it was expensive.
Next up, Rob Schubert. You all know Rob. If you don't, you should. Rob's one of the preeminent builders in this town. And Rob will share his experience with 250 West 55th Street.
As Ray says, you want to stay out of court, and you never want to see these guys under construction. So, preface this, for 250 West 55th Street, prior to this, we did Boston Properties did 2 buildings in Times Square, surrounded by subways on all 4 sides, with the exception of one historic building, the New Amsterdam Theater, that we managed to build a 1 million square foot building without even cracking the paint next door. This project, however, was just the opposite. We had all of the bells and whistles. So the site is a 1 acre site between 54th and 55th, bounded by 8th on the west and by 2 relatively low 4-story buildings on the east side. Designed by SOM, it's a 38-story building with 2 50,000 square foot below grade floors, 1 million square feet. When we acquired the property, there were 9 existing buildings on the site, mostly small 4-story tenements, but there was a 14-story building on 55th Street that used to be the Hearst Corporation headquarters. And then on the south side, there was a building called the Department of Labor building, another 8-story building that I'll get into shortly. This project has a long history. We got through foundations, and partially due to the fact that we ran into the problems I'm going to talk about, the project ultimately got caught up in the financial crisis. The 500,000 square foot tenant that we were negotiating with stalled in terms of negotiations and concluding a lease, and ultimately we mothballed the project for about 2.5 years. We restarted the project in 2011, and the first 250,000 square foot tenant is moving in this weekend. So this gives you an idea of the site, and not only did we have the building next door, we had actually one of our own buildings next door. This building here called Lot 103 was one of the tenement buildings, and we went through a whole long procedure of buying out the tenants, getting these little residential tenants out, but as always, there was a holdout. We were prepared to build around this guy just because we had to for our schedule. Ultimately, we did come to an arrangement with the gentleman, and he vacated it. But that's basic. You'll see a better photograph in a second. And then it comes to Lot 9. As part of the acquisition, we own the air rights to this building. We had a license agreement to underpin the building. We had everything that we needed to get DOB permission, in terms of forms for underpinning, the whole 9 yards. And I got a call the day that I sent the DOB forms for the adjacent property owner to sign. It says, I don't care. Buy my building. And it was, tens of millions of dollars. And this building here is actually 3 tenements stitched together, rent stabilized, rent controlled buildings. There were some tenants in there since the 1950s. So this gives you an idea of what the site looked like when we acquired it. This is the Hearst Corporation old headquarters, about a 14-story building. The tenements that I mentioned along the 8th Avenue, and this gem of a building called the Department of Labor building, and I'll get into that in a second. So this gives you this is a view looking west on 54th Street before demolition. So the Department of Labor building is sitting here. This was the Lot 9 building, which still exists today. In fact, now there's another hotel sitting next door to this one as well. And it was indescribable in terms of how many issues that we came up with. In terms of doing due diligence, we did all the due diligence that we could possibly do. Unfortunately, we had limited access to both the Lot 9 building and the Department of Labor building. The Department of Labor had a lease they wouldn't get out. We had very limited access to get into this building, to do probes, to find out what the heck it was. And in my 35 years of doing this, this is the most bizarrely constructed building I have ever encountered. It had cast iron columns. It had Republic arches. It had plate girders on the 7th floor, because apparently it was an automobile showroom at some point in time, and that was all done after the fact. We didn't know any of this when we got into this monster. And so it was a very interesting demolition process. This gives you, this is the Lot 103 building. The Hearst building is almost all the way down already. This 14-story building came down like a charm, not an issue. The adjacent property owner worked with us, gave us all the access we needed, and then there's this Department of Labor building. And so we brought it all the way down from the 9th floor down to the adjacent parapet of Lot 9. And lo and behold, when we got down there, it's difficult to see, but this is the Lot 9 building west wall. It was 2 wives of brick thick, and we didn't know it. And so my friend Tim here graciously gave us a stop work order till we figured out what the heck we were. It was totally justified, but very frustrating. And you can see here that this is the the floor spandrel of the Lot 9 building, and this west wall is 18 inches thick, and it was basically glued to this thing. So if we tore this down, this building is going to fall down. And so we worked with Tim and his group and with a variety of structural engineers and shoring contractors to basically, we had to do 2 things. One, this is where Ray got involved, and we went through 9 months of court proceedings. And what initially started out with as a proceeding to get permission to underpin the adjacent building, it quickly devolved to something else, which was, and Ray mentioned it before, where you have to go in, tie the floor joists together, and stabilize the existing building. Well, if you see all of these channels, what this represents is us drilling a hole through the adjacent building, opening up the ceiling in the adjacent apartment, putting a plate on to basically stitch the floor joists together to secure it to our building. So what we ultimately ended up doing was leaving the 18 inches of existing construction and underpinning that. We never, in fact, underpinned the adjacent building. We underpinned our own building and stitched the adjacent building to it. But what this represents is 2 things. We had to come up with a procedure in which to stabilize the existing remaining bay of the of the DOL building, which meant we had to put in we had to build a building in a building. So this is all structural steel stabilizing this wall, stabilizing the floor plates, and we had to do it floor by floor by floor. It became a nightmare. What happened, this is what you're seeing here is after we got the building stabilized, it's got structural steel, and it took us about 4.5 months under a partial stop work order, and basically, many meetings with the DOB in terms of going through and sequencing how we went down, because again, as we opened stuff up, we didn't know what the heck was there. And so ultimately we got to the point where we could remove the entire building. And this is what you're seeing here. It says the Lot 9 stabilized, but this is the remaining 18 inches of wall of the DOL building. And what started out as an underpinning job, what you see here is once we had the whole thing down, and this is where it's excavated, this line is a little off, but that is street level. That is street level. And then this is all of the underpinning that we had to do to hold up this adjacent building. So we went through, as going through the whole court proceeding was a painful process. We actually needed a court-ordered schedule to go into each individual apartment. Mind you, it's a 100-year-old tenement. We had to abate the lead paint. First, we had to relocate the tenant for a temporary period under a very strict schedule. We had to go in and do lead abatement because it's all lead paint. You don't want to disturb anything because you're going to rip the ceilings open. Tie the building together, and then we had to go back in and basically we sheetrocked all the apartments, and everybody got nice new apartments, and some of those apartments hadn't been painted since 1964. So, with all good intentions, we had all the legal documentation that we needed, but this whole slowdown ultimately resulted in us losing a tenant. We ended up mothballing the building. This is basically the 1 acre floor plate mothballed for 2.5 years. But eventually, we got to build a new building. So, I urge you to, when you're considering, constructing constructing a building and you've got next door neighbors, do all of the possible due diligence you can. It's extremely cheap money. Good relationships with the neighbors is sometimes really impossible in my case. But if, I urge you to do as much as you can to get access to the existing building, to, establish a good license agreement that allows you to do what you need to do quickly. Because, the alternative is it can slow you down and cost you a great deal of time and pain.
Now a fellow who everybody needs to be very nice to, Mr. Lynch.
The real risk to bringing a new building out of the ground is rarely the building itself, which you have a lot of control over. The real issue is what's on the lot line. And in New York City, we're a very dense urban environment, and we've been a dense urban environment since 1812, since the Commissioner's Plan. We have a population of 1 million buildings, and it's, as a regulator, we don't, we're not the developers and we're not advocates for the buildings, but we regulate the new buildings. And we've had regulations in this city since the 1600s and even before then. And it's clear because you've got fire and life safety, you've got a material science, you have an engineering issue, you have a zoning issue, and you have a protection of the citizens in New York. And building in New York can be, has a lot of problems. It's dense. You're on the lot line. You're cheek and jowl with your neighbor. You're in a relationship. All of a sudden, you're in a relationship with somebody you didn't intend being in a relationship with. You're dealing with vintage buildings. And the real governance in this issue, dealing with existing buildings, is it's very difficult to get your hands around where you stand with them relative to their structure, not relative to their occupancy and relative to the relationship with the neighbors. You can sort of get your head around that stuff. The real problem with the adjacent buildings is how structurally stable they are. And the structural stability of the adjacent building is not negotiable. A lot of other stuff is negotiable. There's not a lot of textbooks that guide this work well. A lot of this governance of how these vintage buildings were built actually don't turn up in textbooks. They actually turn up in historic codes. And a lot of people don't know that. And I've been at this for close to 30 years, and I find it's like mercury slipping through your fingers, trying to get your head around how these buildings are structural, what makes them stable, what are the ground rules that actually make these buildings, workable. What actually makes these buildings stay the way they are? How did we end up in this position? Because we want to develop the city. Buildings, they age, materials break down, zoning changes, occupancy changes. The need to develop is important. The real risk to the development is the stuff on the lot line. Everything inside your construction site you've got control of. So what codes do I look at? If you can't find it in a textbook, you can't go to a design consultant that has the institutional knowledge. There are very few people in this room that have the institutional knowledge of what happened in the building codes before '68. Because what really happened in the building codes before '68 is with a lot of empirical design and prescriptive design for these mass buildings of buildings. Same type of buildings, you squeezed them out like sausages. You didn't design them individually. They were designed off a pattern book. And the problem with that is that there was governing codes for that stuff. And everybody said, okay, you got a type A building, this is what you do. You got to make sure you brace the walls. You got to make sure that, is engineering a big issue? Well, if you build enough of them stuck together, they've got a lateral support system. They don't sway back and forth. And that's generally what was understood with these buildings. And was there an alternate load path? No, but it's a great idea having an alternate load path. So you find a lot of fire prevention migrated into this thing because you had progressive collapse issues with these buildings. And they've had this issue with adjacent construction dating back to the 1800s, and it's been memorialized in codes. So this is what we have. The codes date back to 1625. I can robustly get a code to the 1600s. And why do we look at the codes? It's a boring topic. It's a snooze. But the real problem with the issue with the codes is there's a lot of keys to unlocking how the buildings were put together. Why? Because they were prescriptive, empirically designed up to about 1915. And then what happened is you get individual buildings individually designed. You've got the Empire State Building going up before the 36 code, basically written under a code for buggies. Why? They had the engineering know-how. It was the engineering, they knew about how to design these buildings way back in the 1700s. They didn't have it as a material science issue. So what they had is for these empirically designed buildings, which there was hundreds of thousands of them, If you swap out 2,500 buildings a year and you go back to the 1936 when they really started to individually design buildings, you only have 100, 150,000 buildings. What about the rest of the million buildings that are in the city? All of those were built under the existing codes at the time. So you really got to go back. So I look at these old codes. There's one from 1755. Everything south of the Collect Pond, stone walls and slate roofs. That was the provision in the code in 1755. Why? Because it was less fire threatening than wood frame construction, and they didn't allow thatched roofs. So what have you got in the building code? What is the essence of it? What is the real, if you look at what's governing this universe, you can parcel it up into three packages. It's a duty. Then you have a technical provision, and you have a site safety. That's what you got in the 2008 building code. And you kind of have it in the 68 code, and you have a very early version of it in the 38 code. So this is little Rosetta. You know, it's, so what we've got is really most of the people in this room, you're on the top, you're about from 11 to 2 o'clock, which is the permitted of the new building, permits for new buildings. And most of the people is in that universe. The other problem from 2 o'clock back to 11 is the building and service. And that lasts 100 years. Okay? So you've really got your permits and that you've got the buildings in use. What have you got on the lot line construction with the existing buildings? Have you got a building that's permitted, that's under construction permits? You do not. You have a building governed by a C of O. And the whole setup for that building is different. It's in an occupancy. It's a building that's been standing there. It's just working for a living. It's not under construction. If you want to find out how frail or how stable that building is, you need a toolbox for it. Okay, so what have we got? Here's two different types of buildings. They now have C of Os. The building on the top left-hand corner was absolutely engineered. It's from the 20s. It was a primitive code, but it was engineered. They had the material science. They understood how the columns worked. They understood how the connections worked. They understood load paths. That building was engineered. It's not empirically designed. And it was designed and it was built before the actual code got to a point where it said you must start using engineering theory for this thing. The bottom right-hand corner is a masonry, unreinforced masonry building, which is actually empirically designed. So it has a different toolbox. Those empirically designed unreinforced masonry buildings are the ones that move around a lot. The frame buildings have a tendency to get your hands around. You know where the loads are. You can understand the engineering principles. Usually you can find drawings for these things. The bottom right-hand side, there is drawings, but you've got to know where to look for them. Undefined load paths. Alterations, frail walls. Why are these things stable? Because they had some very basic rules that made these buildings stand where they are. They were locked in with each other. They didn't move left to right, very low aspect ratio. All the walls were locked in. The wall thicknesses were governed in the codes. It actually said what wall thickness. It was governed in the codes from 1835 onwards. Floors, usually floors, they deflect. But one of the rules that was set up in the building codes is you got to prop them around the stairs. Who cares if it deflects? We got a secondary, we got something around the stairwell that props these floors. It wasn't important. They kind of got around a lot of the engineering issues by making these sort of empirical design rules. And that's the snag with a lot of these adjacent constructions. They actually are empirically designed. They're hard for the engineers to get their head around. Okay. We recycle sites all the time. There is nothing new about the discussion we're having today. It's been around since the 1600s. We have this is the same site on 6th Avenue right now. They recycle these sites. And there's been rules governing the adjacent construction since the 1800s. I'm going to show you a provision that's in the 1855 code saying you must protect adjacent buildings. A lot of this stuff for the adjacent buildings is actually that's in today's code. You can see the genesis and the family tree going all the way back to the 1800s. We recycle sites all the time. This is why I think that circle's useful. Because it's not like we take a site out of service. Most sites actually get recycled. And when they get recycled, how long have we been recycling sites in the city? Since the 1600s. There's always been something, mostly on these sites, basically from about 1812 onwards. But in Manhattan, these sites get recycled a lot. So what you think is new and it's a problem and we got the neighbors, there's nothing new with this. Okay, and this is template buildings. These are your sausages, old law tenements. The building codes in 1835, 1855, and 1886 required plans to be submitted, but it was elective. Are they stable? They're standing now. Okay? I want to make sure they stay standing. Okay, and here's some code provisions. Fire cuts and a cumulative load. You know, they had some engineering guidelines on some of this stuff. People say, oh, you can never find any data on this thing. Actually, that's not quite true. There's not a lot in the textbooks that govern it, but if you actually look at the building code and the provisions in the building code, it was actually quite tightly spec'd. Okay, so you've got a duty that you've got to use sound engineering design, safe construction, demolition practices, blah, blah, blah. Where is that found right now for the duty for maintaining the adjacent building? So you're up out of the ground already in Chapter 33, generally. That's a dialogue you've got to have before you get to the site. Adjoining wall, Chapter 33 as well. So if you sort of contemplate these risky issues very early in the job, there's nothing to say that that site that you're developing is exactly right for that site. The 30, 40-foot deep basement may not be suitable for that site because you could have this, you know, banger on the lot line that you haven't really taken into consideration. We've all had those stories. But there's nothing unusual about them. You can figure out how they're engineered. And there's the 1855 code. I'm just giving you a sample that there's nothing new about this. It goes back 170 years and even older. The protection of the adjacent site to maintain these is good for business. It's in the code. It's not elective. It's just what it is. And most of it can be boiled down to engineering issues, and it can be risk analyzed. And that's what my job is. I have to make sure that everybody keeps these adjacent buildings safe. I don't always stop them. I let a lot of jobs go, and we bring a lot of institutional knowledge to the site. And we negotiate with the neighbors, and we help, and we dialogue, and we bring engineering, you know, to the neighbor's lot. We can help with orders there. You know, we do a lot to mitigate these sites and bring them up out of the ground, the new development sites. We work with the neighbors. Usually we have a relationship with some of these guys. And it's not all about stopping the projects. We want to put people to work as well.
Next up will be one of those structural engineers who has to keep Tim happy, Mr. Stephen D. Simone, President of D. Simone Consulting Engineers.
What we see today, you know, building in a dense urban environment, I think is a lot like raising teenagers, and I'm raising teenagers right now, so I'm particularly tuned into this. You know, it's really about choices and responsibility. And choices are choices made by the developer. How deep do they want to go? You know, we have development clients that are spending upwards of $1,000 per square foot for buildable FAR. And for me to sit in a meeting and try to convince Stephen Roth that he's not going to go down 3 levels on his new development project is really a futile exercise. In terms of responsibility, I think in years past, who is actually responsible for the design underpinning the protection of adjacent structures is usually been pretty muddled. I will tell you that I've had my fair share of legal scrapes, and the only time I've ever been sued personally was on an underpinning case. And you can imagine how well that went over at home with my wife. So, you know, in years past, just to recount, as engineers, as the engineer of record for the new building, we would put some typical underpinning details on the drawings for the sole purpose of filing the set and getting a permit, with the understanding that the contractor would then hire a presumably more qualified engineer to actually set out and develop a plan of underpinning and protection of the adjacent structures. At the time, it usually worked until there was a problem. I think it's very difficult to sit across from opposing counsel and say, look, those details that we provided on our drawings were merely suggestions. When in fact, 9 times out of 10, the contractor would cut and paste our details, put them on his sheet, and that's what they would submit to the building department. Things have evolved, I think, at the behest of Tim and his team. Currently, we need to have a standalone supportive excavation set of documents produced as part of the filing set. 9 times out of 10, we don't do it. We usually rely on people significantly more qualified to do that, like my colleague Alan Popel at the end of the table. We like to think of these new support excavation drawings really as site preparation plans. I'm a new building guy. We like to think our work actually starts when the excavation is complete. I know that's a bit counterfactual here, but I will tell you that with a $200,000 self-insured retention, I've spent upwards of millions of dollars defending our firm in underpinning cases, property damage cases, where we had absolutely nothing to do with the underpinning design or the design and protection of the adjacent structure. So I come at this a little differently. I think that there's opportunity to continue to refine and redefine the roles of each of the participants. But again, ultimately, the developer or the sponsor of the project should be responsible, along with the contractor, for any damage that's incurred by the adjacent property owners. Again, we sort of look at the process differently, more from a risk mitigation standpoint, in that we like to think that our work really starts when that site's protected, underpinning's complete, excavation is down to the lowest level, and that's where we as the new build guy starts. Now, does that mean that all of that other engineering shouldn't be done by a competent engineer? Absolutely not. We believe that it should be. We believe that the responsibility should be clearly delineated. We believe that the protection, as Tim mentions, a lot of the data for these buildings exists. You just have to look hard for it. Some people do that well, some people don't. But again, if you have a set of documents clearly delineating whose responsibility it has been up until that point to underpin, to design the underpinning, to provide the protection and bracing of the adjacent structures, I think that would go a long way to prevent what are at times protracted legal battles. Michael and his esteemed firm are currently representing us on an underpinning case that dates back to 2000, Michael? So, it's still ongoing, and it's currently in the, potential damages in the multi-million-dollar range for a building that was probably worth about $1.5 million. So I think there's still a lot more to go in terms of, again, delineating responsibility, providing really a pass-through legal system that can sort out a lot of this. If we had a construction court here in New York, that would go a long way, where we could get in front of 1 or 2 or 3 judges that knew the process, knew everybody's roles and responsibilities, and could sort of weed out the static. Unfortunately, even the best laid plans go awry. So in New York, there's going to be damage. I mean, we spent millions of dollars on a project recently, did what I consider to be the Cadillac of soil retention systems. We had a water main break, washed out a lot of the soil under the adjacent property, and we still had damage, even though we were using 24-inch diameter caissons and poured concrete earth retention walls. So it's going to exist. How can we get that process moving? How do we get the resolution of those issues to happen faster? And how do we really delineate a clear chain of command and a clear responsibility? I think those are challenges for the industry and for the building department.
Alan's firm, Langen, specializes in basically from the ground level down, which is a lot of what this is about. So it'd be very, very interesting to hear Alan's perspective.
Obviously, there's a lot of passion about the subject. I mean, Tim, that was Tim's abbreviated version of the talk, if you could believe it. So there's a lot of passion out there. But I'll echo what he said. There's a lot of projects where the most complicated part of the project is dealing with the neighbors. Financial district, Tribeca, west of the High Line. A lot of the hot areas are really poor, old buildings with poor soil conditions, and that's the hardest part of the project is dealing with the adjacent building. And we also see that, and just as a firm, we have offices up and down the east and west coast, and a disproportionate number of the claims against us are third-party claims, next-door neighbors in the city of New York, hands down. So that just statistically, anecdotally and statistically, it's the riskiest work that we do. My perspective is both designer of the New Building Foundation and also designer of supportive excavation and underpinning systems. The things that will happen if you have, especially if you have poor soil conditions, if you have foundation underpinning, if you're installing piles, if you have a dewatering system, sometimes if you're excavating rock, if you're installing a supportive excavation system close and you're right on the lot line with an adjacent building, I'm sorry, there's going to be movements. To say that it can happen with zero movement is, I don't believe it. And with movement comes, now rock is a little different. Sometimes on rock you can get you can do something, excavate a foundation without movement. But for the, you have those conditions, I'm sorry, you're going to have movement. And when you have movement, you have damage. And to me, there's different levels of damage. There's what I would call cosmetic damage. There's cracks in the plaster, which is, is not going to concern Tim, but it's going to concern the apartment owner. There's functional damage, which is walls and, windows and doors stick. And then, of course, there's structural damage where, yeah, the building's at risk and you have to either partially vacate or, in worst case, demolish the building. And, from our perspective, these risky operations are, the means and methods of the contractor are paramount to the success or lack of success of these systems. I mean, we could design a great underpinning system, and if the guy chooses to not, shore or support the side walls, or they do a bad job of the load transfer from the existing foundation to the new underpin foundation, if you've got a very, I'll call it sloppy pile installation or slurry wall design or secant pile wall, not design, but construction methods, you're going to get movement no matter how well it's designed. And I think if I'd like to see one change within the industry, within the building department, is to bifurcate the design and in-place construction with the means and methods of construction. And really, it's the contractor that has he's the one holds all the cards. I mean, we as the designer, I don't have a contractual relationship with the contractor. I can't tell the guy what to do. And the building's there, it's loading, it's foundation, and anything goes wrong, it happens instantaneously. As opposed to a new pile foundation, I can test it, I can inspect it, I can do a lot of things to verify its capacity before building load ever goes on it. But the building's there, and it's going to happen almost instantaneously. And I can't control the contractor. I don't have a contractual relationship with him. So I'd really like to see a bifurcation of those responsibilities formally spelled out. And I know the building department was looking at that, at least in slurry wall designs, because I was down there talking to, Tim wasn't there, but I was talking to some other folks about it. And just, a slurry wall's got a 10-foot wide by 3-foot, 10-foot long by 3-foot wide slot that's filled with slurry next to an adjacent building. And you know what? Somebody should be responsible for that. And the contractor is the guy who's most qualified to do that.
Well, thank you all very much. I'd like to thank the panel. Bye-bye.